Okay, I would like to tell our viewing audience a few things about Mr. Ford in this case. The letter that we sent to Eric Holder is legally detailed. We know that it was investigated, and twice. He first investigated it in the criminal division under file number 1724473. Then it was investigated again down in the Executive Office of United States Attorneys, and that number is control number 2010-0657. We've always suspected that during the investigation, Mr. Holder found out a lot more things that happened in this case that would be damaging to the Department of Justice than what we have been able to uncover. And we have been able to uncover a lot. And I would just like to read a portion of the letter we sent to Mr. Holder explaining, and this is the paragraph we have. Mr. Ford is the only American citizen in the history of the Espionage Act, and that is since 1917, to be charged, prosecuted, and convicted under the statute without meeting the requirements of the statute. The United States Court of Appeals for the Fourth Circuit recently upheld the requirements that in order to charge under the Espionage Act of 1917, Section 793E, one has to have the belief that what one is doing will harm the United States and or help a foreign entity, and one must have the intent to harm the United States and or help a foreign entity. And you can find that under United States versus Rosen and Weissman. These are very hard elements to prove. That's why in spy cases, they investigate you for years. For instance, in the Hansen case, it was investigated for 16 years. The Walker case, investigated for, about 3 years? Yeah. They investigate you so that they can get you dead to right because of the elements involved, the things you have to do to in court, the things that you can't do in court. It is hard to determine someone's belief. Unless you know me intimately, you don't know what my belief is. And that's an element of the charge. And Judge Massetti suppressed that element. He has no authority to do that. Only the United States Congress can change the law, can change federal law. He cannot do it, but yet he did. Also a requirement is that in addition to the belief that you are harming the United States or helping a foreign entity, you have to have the intent to do so. Until I do it, you don't know. I can go up to the curb and it appears that my intent is to step off the curb. But until I step off of it, you don't know what my intent is. I could walk up to the curb and turn right back around. So until I harm the United States or help a foreign entity, you don't know what the intent is. Those are very hard elements to prove. And that's probably to avoid this situation. And Judge Massetti threw it out and told the jury they don't have to worry about that. He has no authority to do that. Only the United States Congress can do that. And Mr. Ford is the only person who has had this done to him. That's why United States versus Rosen and Weissman was thrown out. That's why United States versus Thomas Drake was thrown out. That, in addition to the fact that you must disclose to the jury who represents me, the public, you have to show the secrets that have been divulged. And in doing so, you're giving anybody who wants it, the enemy what we're doing. NSA is not going to allow that. CIA is not going to allow that, or any of the other 7 spy agencies. They're not going to allow that. So that's why you catch these people dead to right. You have to. Now, those 2 affidavits, even the way they stand in the real world, would not have been issued search warrants, because there's no probable cause. Just because someone calls law enforcement on someone else, which turned out to be untrue, but even if it were, that's no reason to issue a search warrant. People are calling now on everything. You have to have proof. That's why you investigate. Also, we informed Mr. Holder of 3 indictments that were issued on Mr. Ford. Only 2 are on the docket page. His first indictment is not even on the docket page. I'd say that's illegal. It wasn't real. The second one, supposedly, they went to the grand jury. Now remember, all of this is illegal because all of this has to come through the assistant United States attorney. At that time, it was Alice Fisher. The third indictment came the day before the trial. I found this on the docket page. There was an indictment, an arraignment, and a plea from Mr. Ford of not guilty the day before the trial. I don't know what they were trying to fix. Okay, Mr. Ford wasn't there. He wasn't there. Even if he were there, you cannot have a jury trial the next day after an indictment. Impossible. Why? Because the speedy trial clock starts again. The speedy trial clock starts the minute you come into court to face the charges. The minute you come in to be read your charges. That would have been impossible, but yet on the docket page, there it is, and it is one of our pieces of evidence that we were showing Eric Holder. I'll try to. 29. 29. Yeah, here it is. This is when I found out that on the 29th, on the 28th, there is a superseding indictment. And it says that as to Kenneth Wayne Ford Jr., and it says he was arraigned on the 28th and in front of Peter J. Massetti. And it says that a plea was entered by Kenneth Wayne Ford Jr. of not guilty. And Mr. Ford wasn't even there. He wasn't even there. And this is the this is the docket page. I got these docket pages in 2009. Then on November 29th, the very next day, is day 1 of a jury trial. That can't happen. Attorneys out there, that can't happen, and you know it can. Also, we pointed out to Mr. Holder that under the sentencing guidelines, in order to sentence 793E, there must be a transmittal. All of the recommendations and requirements for sentencing under each section of 793E calls for transmitted material. The commentary, and you attorneys know that in the commentary means just as much as the guideline itself. The commentary says you cannot sentence 793E unless there is a transmittal. What does that tell you? Common sense tells you if you can't sentence it, you can't charge it. The government consistently said that there were no transmittals. Even when Judge Massetti, Peter J. Massetti, was sentencing Mr. Ford, the prosecutor, David I. Salem, jumped up and said, "But there were no transmittals, Your Honor," after he paraded back and forth recommending 11 years for Mr. Ford. And the judge said, "But you kept it there." And he said, "But there are no transmittals, Your Honor." And the judge sternly said, "But you kept it there." And then Mr. Salem sat down. There were no transmittals. There are others. There are other documentations in the transcript where he's saying there are no transmittals. If there are no transmittals, you can't sentence it. If you can't sentence it, you can't charge it. Everything from this, in this case, from its inception on January 11th, 2004 to the present has been illegal. We showed it to Eric Holder. The best he could do was send us back these responses saying that they didn't handle this and we needed to go to a federal court. I wrote back saying, yeah, we could go to a federal court, but you did it for White, Rosen, and Weissman, and the Department of Justice did it for Thomas Drake, and for the exculpatory evidence, you all will remember Ted Stevens. We have the actual motions that were submitted by the Department of Justice to exonerate Ted Stevens after his conviction, then to let the case of Rosen and Weissman go while they were on trial, and to let Thomas Drake go while he was on trial. Well, I wrote back and asked, what about little Black Kenny? What about him? They didn't quite answer that because they don't have an answer. They don't have an answer. But I do know that when this comes forward in court, yes, Ken himself will have a massive lawsuit against the federal government. But this means that cases that involved prosecutor David I. Salem, who's been a prosecutor since 1983, cases involving Special Agents Michael L. Thompson and Frederick C. Marsh, who have been special agents for a while. Frederick C. Marsh, right now, probably, I don't even know if he's still there, but at the time that this happened, he wrote he had been a special agent for 15 years. Special Agent Michael L. Thompson at the time had been a special agent for 4 years. However, we did a little checking, and he had been on the Sheriff's Department in Florida for a number of years. So, also cases where Department of Justice trial attorney Mary Claire Rourke has sat on. And also cases involving Judge Peter J. Massetti, who has been on the court bench since, 1995 or something? Yeah. He had been on the court 12 years. Yeah. That means that cases involving these people will probably come back, because if you did it once, you did it before. Defendants who are sitting in jail will probably file claims. Attorneys who worked on those cases will probably file claims, and this is what Eric Holder knows. In each letter, we have invited Eric Holder to meet with us face-to-face, eyeball to eyeball. He has not done this. He has not responded. But yet in his responses, he does not tell us where in our 12-page letter, the 13th page being a list of exhibits, he's not shown us the error of our ways. He's not shown us where we are legally incorrect. He's not done this. He's given it to underlings who have written back, we don't handle this. And they wrote back in these letters. And then, of course, I will send a letter back. And I found it interesting that on January 18th, and it appeared in the paper on January the 19th, that a Kevin Olson, who was the chief of staff at the Justice Department, had been named in a new position. He's chief of Professional Misconduct Review Unit. And I read that, and I'm thinking, you know, chief of everybody in there. Every criminal in there, every person who purportedly works in there, every rat, every roach, every ant in there. Why would you give that up to go into an office where probably it's no more than 3 or 4 or 5 people in there? So I thought, sounds to me like somebody's back needs watching. I don't know the history of Kevin Olson, but probably in my opinion, or I suspect that he and Eric Holder are really, really good friends. And our letter came in, and now, as you know, Holder is sitting on the Hill answering charges that he did nothing with this ATF situation, and he's sweating over that. And God knows what else is there. And he simply needed someone to watch his back. So I sent Kevin Olson a letter telling him that we had noticed this. And the letter is from my husband and myself, and we sent him a packet. And we even wrote, somehow we know your office, Professional Misconduct Review Unit, was created because of the Kenneth Wade and Ford case. We know our allegations were investigated, and we give the same file numbers I just gave you. We know you found everything we cited in our letter of 11/18/2009 to be true, including wrong jurisdiction. Greenbelt had no right to try this type of case. Our letter is so much on target that the public federal court files of this case are now unavailable. This is what we wrote to Kevin Olson in the Department of Justice. How can that be? There has never been a case as egregiously pursued as this one. We are used to the Department of Justice personnel lying within a case, but this is the first time we are aware of that a case was totally made up. As you now know, not only is Mr. Ford innocent, but nothing ever happened. This is clearly evidenced by our Exhibit B. Remember, our Exhibit B are the affidavits and the telephone records. After a picture was painted and framed by your personnel, then Mr. Ford was placed into it. We know you have problems in the department. That's why your unit was created. Probably other changes, less ostentatious as the creation of your unit, have become effective to prevent this type of travesty of justice from happening again. However, it is the department's fault that criminals were hired. Of course, one was appointed, meaning Judge Peter J. Massetti. But now your fault has become our problem. We want it corrected. The Department of Justice needs to step up and take responsibility for the havoc it has caused in Mr. Ford's and our lives. Mr. Ford deserves to be made whole. As before, we have requested department officials to meet with us. To date, this has not happened. We look forward to hearing from you in a timely manner. And then, of course, we had some preferences to that paragraph where we're telling about what the Department of Justice did in the Ted Stevens case, in the Rosen and Weissman case, in the in the Thomas Drake case, and look forward to it happening in the Jeffrey Sterling case. And we'll also be watching this Bruce Manning case that's upcoming. The letter I received back from Mr. Olson is, I am in receipt of your correspondence dated January 24th, 2011, concerning the prosecution of your son, Kenneth Wayne Ford Jr. I have read the material you included in the packet information, and I have reviewed your allegations of misconduct against the prosecutors in this case, as well as against certain Department of Justice officials and the judge presiding over this matter. The Professional Misconduct Review Unit does not have investigative authority. Rather, the PMRU reviews final investigative reports that are submitted to our office by the Office of Professional Responsibility. We then determine whether a finding of misconduct is supported by the evidence and the law, and if so, what discipline should be imposed. Excuse me. I note that included in the packet of material you sent me was a letter from the Office of Professional Responsibility dated May 18, 2010. In that letter, OPR stated that their review of your allegations led them to conclude that no action by their office was warranted and that the matter was now closed. In light of the disposition of this matter by the Office of Professional Responsibility, I have no authority to pursue the issue further. Accordingly, I regret that I cannot be of any assistance to you at this time. Now, remember, we have sent them wrongdoing several times. We've shown proof of this. This man has been taken out of a position of chief of staff. That means all the Department of Justice in every part of the country, and put in this little office. Sounds fishy to me, and it sounds to me that he was put to cover Holder's butt. In the meantime, no one has offered to meet with us. No one has shown us where we are legally incorrect. We need a lawyer. We need a lawyer, and we need a lawyer who's not fearful. And we need someone honest. And so here we are. Also, I'd like to read you just a little bit of testimony that's a little interesting and funny. It's not funny, but also we sent to Holder. We sent to Holder a copy of the receipt for property received, returned, released, seized from Kenneth's house and car and truck. I have the carbon copy. I'm not about to let hold of that. That's the best I could do. It was written by Special Agent Bridget Bingham. And she said she was the recording agent, and she described how in a search, it was about 25 people in Kenneth's house, tearing up his house, terrorizing him, would not let him go to the bathroom. And this represents 25 guns in his home. Most of the agents were white in a black man's home with the blinds shut. Let me tell you this right now. Kenneth has never been taken, let's say, downtown. He has never been interrogated in a room where there is film. He has never had a statement recorded. Never, because it's illegal. And what I did with this was I so that it could be misspellings and incorrect usage of English and everything that she wrote so that one would know what it is. But what this is are 43 items listed. There is not one classified item listed of the things that were seized. Not one. Not one. He got this stuff back, right? Mm-hmm. He got all of this stuff back. And the papers, once again, they said were recorded, were videotaped and taken pictures of 2 or 3 days later in a FBI facility. This is our Exhibit K of transcripts we did receive, and this is this is Special Agent Thompson, and he's being interrogated on the witness stand, and and I would just like to read this. This is a question by our attorney. Agent Thompson, other than the document that was found in Miss Tucker's suitcase, were Mr. Ford's fingerprints found on any of these other documents? Answer, no. Question, this document, the suitcase document, was the document that Mr. McCaslin brought down to Mr. Ford, correct? Yes, I believe it was handed to him by an FBI agent. Question, and isn't it true that at this time he admitted to having classified documents, correct? Answer, could you repeat that? Question, it was at this time, it was the first time that he had admitted to taking classified documents. Answer, no. Question, all right. At some point after the basement, you and Mr. Ford and Mr. McCaslin went upstairs, correct? Answer, yes. And you told him to write a statement, correct? Answer, didn't tell him, asked him. Question, you asked him to and he agreed to, right? Answer, yes. Can you see this from here? Answer, I'll get up, that's fine. The court, are you asking the jury as well? The witness, I don't think the jury can see that though. Do you want me to get up? The lawyer, Mr. Heck, we can put it up on the screen. The court, all right, why don't you do that? Can you see that up there? Answer, I can make it through. Question, and you started off the statement by telling Mr. Ford to write that first sentence, didn't you? Agent Thompson, answer, I didn't instruct him. Question, is not forcing me to write this statement? Mr. Salem, wait. He asked the question, he's not giving the witness. Mr. Heck, I'm clarifying. Mr. Salem, a chance to answer. The court, ask your question again. Mr. Heck, I'm clarifying. You started off by telling Mr. Ford to write. Agent Thompson is not forcing me to write this statement. Is that correct? That is not correct. So is the testimony that he just wrote that off the top of his head, that's something he knew to write? Answer, no. How did it end up on the piece of paper? Didn't you direct him to write that? No, I said, if I'm not, am I forcing you to write this thing? He said, no. I said, well, you could write that. I didn't direct him to write a statement. Okay, but you told him to write. It's not forcing me to write this statement, correct? I tell him to write that statement. You just testified that you said, okay, well, write that. That's not directing him. The court, all right, Mr. Salem, prosecutor, all right, Your Honor, the juries, the court, the testimony is clear enough. Go on to another question. Okay, the prosecutor had this big statement, all blown up, written by Mr. Ford. This was in Mr. Ford's house. By then, the FBI agents, everybody else had left. There is now, this is 7 hours, close to 7 hours later, Mr. Ford and Special Agent Thompson are in the house. Mr. Ford believes they're the only two in there, but it turns out it was another one outside. And they're in Mr. Ford's house. They have the blinds closed. Mr. Ford is a black man. Mr. Ford is writing everything that is asked of him. He's doing everything asked of him because he is fearing for his life. Mr. Ford wrote a 5-page document, which I won't read. It tells of these are the events of what happened when I, Kenneth Wayne Ford, was arrested and the day before. And this went to Eric Holder. And this is, Mr. Ford wrote this. And he is telling everything that happened, the fear that he felt, the fear when Special Agent Thompson pulled out his weapon when he escorted Mr. Ford to his basement. The fear, all he could, and he writes in here, all he could think about was being shot dead in his own home, and them saying that he resisted arrest or made moves against him. Then he's telling how one of them kept bumping his leg, trying to get a rise out of Mr. Ford. All he could think about was being shot. He's also telling shot and killed. Then he's telling about how scared he really was. And toward the end of the evening, Mr. Ford writes, Thompson left the room telling me to be seated and not to move. He was visibly upset. I had to go to the bathroom but was too scared to ask. I thought if I moved I was going to be shot on the spot and a story would be made up about me being violent and they having no choice but to kill me. I was really scared. Thompson left another FBI agent to watch me. Finally, because I had to use the bathroom so badly, I suggested to the agent that I could use the bathroom and leave the door open. He went somewhere to ask Thompson. Thompson was out of my view. It took several minutes for him to get approval for me to use the bathroom in my own home. After I came out, I sat down on the love seat in my family room. I began to notice that the other agents were leaving my home. After about 1/2 hour, Thompson returned and had calmed down. The other agent left away from my view. From what I could see and hear, I felt Thompson and I were the only ones in the house. It was then that Thompson told me to write out a statement. I asked him what I should write. He told me anything I wanted. I asked him how should I start off. He told me to start off with, Agent Thompson is not forcing me to write this against my will. Because of the events of the evening and the document McCaslin and Thompson showed me from Tanya Tucker's suitcase, I wrote that I had classified papers, but I have no foreign contacts. And he wrote this because he thought he better. By this time, from what I could see and hear, I felt Thompson and I were the only ones in the house. I was so afraid of being killed that I wrote exactly what I thought he wanted me to write. I would have written anything, done anything, or said anything to get out of there alive. I was just that afraid. I knew I had been set up, and I did not know how deeply the setup went. I didn't know who was involved, and I was terrified. All evening, Special Agents Thompson and McCaslin made everything I said seem incriminating. And then later on, they told him, then after everyone seemed to have left, Thompson told Mr. Ford he was under arrest. Then Mr. Ford wrote, he handcuffed me and walked me upstairs to get my shoes. I had on my bedroom slippers. He put my shoes on me. He walked me downstairs to my coat closet. He was able to get my sweater on me. I put my jacket on me. He put my jacket on me and zipped it up to my shoulders. My hands were behind me in handcuffs. I asked him if I could at least call my parents. He said, no, it's late and we would not want to awaken them. Then what turned out to be at 12:50 a.m., 1/12/2004, Thompson walked me to a car sitting in my driveway and put me into the back seat. There was another agent driving the car. I thought they were taking me to a remote spot to kill me and hide before. I have never before experienced the terror that I experienced for 7.5 hours the evening of 1/11/2004 into the morning of 1/12/2004. And this is being done to a person who has signed up to give his life for the President of the United States of America. This is what these criminals do. This is what the Department of Justice does. No, they're not worthy. They're not worthy to kiss Kenneth, you know what, and I mean it. I mean it. And I invite Eric Holder to answer these charges. See me in a public place. I'm not meeting anywhere private with you because I don't trust you. And I want the cameras there. And explain to me why it is legal to frame somebody and put them into something that didn't even happen in the first place. Why it is illegal, why it is legal to break the laws, why it is illegal to change congressional laws without Congress, why it is illegal to break the Department of Justice's rules and regulations that have been established. Explain that to me, and explain why you don't handle any of this. Explain that to me, Eric Holder. If you want Obama to explain it, I'll accept him. Explain it. Also, in Agent Thompson's testimony, after he tells about that he admits to telling Mr. Ford to write, and by the way, Mr. Ford is not concerned about anything else except that that the world knows that Agent Thompson is not making him write this. That's his only concern, is Agent Thompson. Yes, he told him to write it, and I would have done anything it would have taken to save my life too, and so would you. Another part of the testimony, the lawyer is calling his attention to a specific item, and that it took place on December the 19th, and that it's still concerning this so-called confession. And the lawyer says, that whole second paragraph, you wrote that, didn't you? Special Agent Thompson wrote that. He answered, yes. Then he said, is this your custom? He answered, yes. So it says, so your custom is to write a statement for him? He said, I didn't write his statement for him. This is his. And then the question, this is his statement, isn't it? The answer, the first paragraph is his statement, yes. And then the question, you don't think that's a little inappropriate, Agent? And then Mr. Salem, the prosecutor, objects. Now, most objections were sustained by Judge Massetti, no matter how stupid. And most objections by the prosecutor were sustained by the judge. And most objections, though few, were not sustained for the defense by Judge Massetti. And then there's one other thing where the whole time the prosecutor was making the case that Mr. Ford loaded up his pickup truck with all these documents, and see, it was so many. Every day the prosecutor would come into court with these it looked like boxes that had craft paper around. He would wheel, 2 hand trucks? They had 2 hand trucks, and he would sit it in front of the jury. Never opened it, but this was to give the impression, these are the top secret papers that were taken from Mr. Ford's house. Every day they would wheel these things in, coming down the hall, going in front of the jury, setting it in front of, then wheel it out. And so they showed a picture of Mr. Ford's pickup truck, not sitting at NSA, but in at his home in his garage. They showed a picture, and they kept it on the screen. And they were saying how he would take this truck and load these papers up. And all this supposedly happened on one day, December 19th, 2003. Nobody saw him going back and forth with these papers. It was thousands and thousands, according to the prosecutor, sheets of paper, and mounds and mounds. But then on the other hand, they were in these 2 small boxes. So, I mean, anything went in the Massetti courtroom. And so, finally, his then supervisor said she saw him on that day. That would have been his last day at NSA because he took the next 2 weeks off because he hadn't been off in I don't know how long, maybe well over a year, and he knew on the new job he would not, he wouldn't want to take off on a vacation for a long while. So he took from December 19th off until, and then he went back on January 2nd, 2004 to officially sign out of NSA, and he started the new job doing the same thing at Northrop Grumman on January 5th. Monday, January 5th, 2004. So the then supervisor or mentor says she saw him in the parking lot that day, and she said that Mr. Ford said goodbye and nice working with you and this, that, and the other. And so she testified then Mr. Ford got into his cream-colored sedan. Now remember, all this time it was his Ford F-150 pickup truck, because you had to give the impression he needed a truck to haul away all these papers. And remember, this is NSA. You have cameras everywhere. You have guards everywhere. The gates are guarded. They randomly search people. And here's Mr. Ford driving out with these papers just stacked on the bed of his truck, just driving confidential papers right on out NSA, and nobody sees him. So the supervisor says that she saw him in his cream-colored sedan. Sedan, what? Huh? So the attorney says, okay, on that particular day, do you recall what color car or vehicle Mr. Ford was driving? She said, it was a car. I remember it being a light-colored car with a tan interior. And then we go further down. And she says, the question was, I just want to start by making clear something that you said just a couple seconds ago. You noticed that Mr. Ford was driving a sedan on his last day, right? She said it was a car. And the question, it was a car. I just want to be clear for the ladies and gentlemen of the jury, it was not a truck. She said it was not a truck. By then she said it a little indignantly, because she's saying, I know the difference between a truck and a car. She said it was not a truck. So from that point on, and this is evidence because we're telling Holder this in the letter. From that point on, the pickup truck became a vehicle. It became a vehicle. Now, it was pointed out, what about the cameras? Okay. It was testified to, and the prosecutor pointed out that that building didn't have cameras. NSA, no cameras. No cameras, NSA? Okay, so Kenneth has a plaque from the award that he received when he first went to NSA with the names of the people, including his own, signed onto the plaque, around the plaque, and it shows a picture of that building. And right at the top of the building is a camera. So the attorney brought it in and showed it to one of the witnesses and said, what about, isn't this your building? Yes. Well, isn't this a camera? Oh, yeah. Well, see, what happened was we discovered during this investigation that the camera was broken. This is NSA, listening audience. This is NSA. Mom and pop stores have video cameras. Private homes have video cameras. You can get them at Walmart. And you know when they're not working, but poor little NSA, they don't have this technology or capability. First of all, they don't know they have cameras, and then when they find out they're not working, and they just didn't know. Also, I'd like to point out to you testimony from Agent Bridget Bigham. and she was the recording agent. And she testified that when they go in, an agent is designated as the recording agent, and that's the agent that's filling out the search form that I showed you, the copy that I showed you. And that agent picks, and she explained, that agent picks a spot in the house. All the other agents who are searching are well aware of where that spot is, and as they find whatever that they feel is incriminating, they bring it to that agent, and that agent takes and records it. So she had already explained that. So this is part of her testimony. The question was from our attorney, from Kenneth's attorney, okay, going back to that evening, is there anything about any of the evidence that was seized that night that you can specifically remember? Her answer is yes. What is that? Her answer is, it was Agent Mark Moss called me into the kitchen and showed me a box that had Kenneth's name on it and also the words top secret. It was a box filled with documents and pamphlets. He had lifted one out, and it clearly showed top secret. And I'm sorry, the prosecutor is asking this, and then Kenneth's attorney objects, and then the court calls them up to the bench, and then of course it's this open space which was taken out. So when they come back, Ms. Rourke is asking the question, Special Agent Bigham, can you please just clarify when you said he, who is the he that you're referring to who showed you the documents? She says, Agent Moss. So again, what did Agent Moss do with the documents that you saw? Answer, it was in the box. He had lifted it up and showed me that this was a classified, possibly a classified top secret document. And he said, how should we inventory this in place? I said, no, my best. It's choppy here. What we should do, because we don't know what's in there, put it back, seal up the box, and take it to a skiff and have it inventoried there. The question, why did you recommend that you take it to a skiff? Answer, because I wasn't sure of what level of classification items were. It was also a numerous amount of items, and in a skiff you could do it correctly and take pictures, and with all those people in and out, it would be just safer to do it that way. Excuse me, but you knew during the search that you were coming to allegedly find top secret documents. The search would have been conducted by people who can view top secret documents. Why in the world are you sending people who say they can't view top secret documents? And another thing, I didn't know a thing about top secret documents or anything, because this is not my field. I feel like I know a lot now. But it is now my understanding that people who deal in classified work, nowhere on a document is it talked about as being classified. It's not. It doesn't even say top secret. It doesn't say secret. It doesn't give you any indication that it is a secret document. So these people are lying on the stand. So then the question from Ms. O'Rourke on the prosecutor's team, the DOJ trial attorney, is, okay, and to your best recollection, what was done with that box that you saw Agent Moss pull the document out of that had the classified markings on it? What happened to that box? We closed it up. We brought it in the room where I was staying. We sealed it, and I put it on the evidence log. So you don't know what's in the box. And where was that box during the whole evening? Next to me in that room. And why was it next to you? I stayed there with all the evidence that was being brought during the search. What role, if any, does the photographer play after all the pictures are taken upon the initial entry of the house? Answer: the photographer will take pictures of any significant finds during the search and will also take exit photos after the search. So those papers obviously weren't significant. She didn't take pictures of it. But wait a minute. She wasn't qualified to do so. Just to document where they were found and what condition they were found in. Question: why do you want to document where something was found? Answer: in case any questions come up during any procedures. Question: now, if and when an item is found, discovered in a house that is of significance after the FBI determines it needs to be seized, how does that happen? What is that? What is that process from the time it's found until it gets to you? The person locating the evidence will, if it's an item of significance that they think needs to be photographed or a question, they'll call me. It's decided in this particular incident to get a picture of it in place, if not several. See, in place. Then it was thought to seal it as it was found and brought to me and then put into the proper paperwork. At the end of the evening, what do you do with that evidence? I will take it into my custody and take it back to the office and secure it. In this instance, because it had to go into a skiff, which I did not have access to, I signed the evidence and chain of custody sheet over to Agent Moss for transportation. So in other words, this agent rides off into the sunset with top secret documents. Now, it's already been said nobody's qualified in there to look at them, so he rides off into the sunset. How silly is that? So then in other testimony, it goes on to say that I believe the photographer testifies that these papers were put on a skiff and at an FBI facility 2 or 3 days later, and she took pictures of them. Now, the only one, and remember, these papers don't have Kenneth's fingerprints on them. That's already been testified to. But yet these were Kenneth's papers because they had writing all around the edges of notes he had taken. So the prosecutor, these are Mr. Ford's. Well, yes, they were his, but remember, they don't have any fingerprint. His fingerprints aren't on them. Now, his fingerprints should have been on them because he made the writing. So what are these? These are copies. These are copies provided to the FBI by the lady who is who I talked about earlier, who was then Kenneth's supervisor, who's in the disguise. She's the only one who could have provided that. Mr. Ford wrote around the edges, but yet the special agent said his fingerprints weren't there. So I'm telling Mr. Eric Holder that no, his fingerprints weren't there because they were copies. Now, how did she get the copies? Because when Kenneth transferred out of her section into a new assignment based on the program he was in, he had to mail those classified papers into the new office through NSA mail under NSA procedures. That was done. This woman testified that she was in possession of Kenneth's papers for at least 8 weeks. That is plenty of time for her to copy them. So when Kenneth sees this, he has already destroyed these papers through the burn system that's in place at NSA upon his leaving there. the real papers. So my husband and I have sent Eric Holder this letter. We are pointing out these things. He has not given not one reasonable explanation of how this could have happened and why we are legally wrong. We've shown him evidence. We've given him legal precedence on every accusation we've made. We have made about 16 accusations against his people. We've asked for meetings with him and or his officials. We have told him we have more. So